Please, my lord. My lord, I'd like to mention item number 1, my lord. This matter may be fixed on 9th of this month. Item number 1, my lord. So Mr. Ave is coming from Delhi. So he will be here on 9, my lord. 9th of this month.
This is an appeal of 2023.
9. Yes, my lord.
You want to do it on 9th. 10th is not possible.
Not so, let it be after the.
You take either do it on 8th or
Leading
9th
cause.
at best, and 9th we can accommodate, but not on 10th.
My lord, leading counsel, Mr. Abe is
Then it goes after view. We can't fix a date.
after vacation, my lord.
Yes.
All right. Much.
Both says a representative on the fair made by the council for the appellant, the matter stands adjourned for the list after entering vacation.
Much.
Yes.
Mayor, I'd like to mention item number 4 on
Item-
behalf of item number 4 on behalf of MK Sharma. This matter may be listed after Puja vacation.
On behalf of whom?
MK Sharma.
MK Sharma.
Yes, Your Honor.
These are all connected matters, no?
Yes, Your Honor.
Item 4 to 9. No, sir.
No.
It's
Only item
four.
number 4, Your Honor.
Four is IAS there also.
Okay, it's okay then. Then they're not required. Okay, then we thought that it's a connected matter. That's why. Okay, both sides are represented on the prayer made by the council for the appellant, the matter stands adjourned today. List after entering vacation. So it is made clear that it would not be adjourned on the next date of listing. Next date will not be adjourned.
Pleasure.
My pleasure.
Lordship, we have checked the record. It seems that's been already admitted. The case has been already admitted. So hearing may be fixed some other day, Lordship.
On 7/9/23, Your Lordship, the matter was admitted and relevant records was also called for, Your Lordship.
Just a moment.
7/9/23.
Yes, what you are saying, Mr. Singh?
Lordship,
What were you saying? I did not get it. Please repeat what you had said.
on 7/9/23,
Yes, we have seen that.
Lordship, yes, Lordship. So apart from that, records was also called for, Your Lordship.
What record? What records?
7/9/23, by order dated 7/9/23, records called for, Your Lordship, it's mentioned there.
It's okay, but what records you have to tell us?
Lordship, the matter may be fixed for hearing, Lordship.
No. First, you see, your first submission was that the records were called for. I'm asking you what records were there to be called.
Regarding Your Lordship, here in the present case, Your Lordship, the learned single judge has decided the matter on 3 issues, Your Lordship.
What records are required? As simple as that.
Relevant to the
Relevant records, we don't know. It can be truckload of records. Please
In respect
identify
of-
the records, tell us what records, then we'll understand. In a particular matter, there will be truckload of records.
Yes, Lordship, I will suggest, Lordship.
Relevant is a very vague term. We're just asking you what records. Because in my limited understanding, record will be only the writ petition, nothing else. We can't go beyond the writ petition. And all matters relating to writ petition are already annexed here. So
Yes, Your Lordship, on the
in
basis
an
of,
appeal, we can't read any record which was not dealt with by the learned single judge. So that's why we are asking you what records you are referring to.
but that may be, Your Lordship, pertaining to appointment of the respondent number 5, Your Lordship, here in the writ petition.
Is it not there in the writ petition?
By way of filing their affidavit in opposition by the respondent number 5, we have brought on the record, Your Lordship.
You see, this issue is very simple.
Lordship.
In fact, we don't find any reason to adjourn the matter. It's only one point. Whether APPSC, APPTST, what do you call, reservation would apply or not. That is the only issue.
Yes, Your Lordship.
So there's
The
nothing.
crux of the case is that of applicability of the reservation policy,
He was
Lordship.
at serial number 1, he was at serial number 5. Correct.
Yes, yes,
But he was a APPSC reserve candidate
yes.
and the appellant was not. And therefore that decision was taken. What is wrong in that?
In regard to that, Your Lordship, the
But Mr. Apang is asking for adjournment. Both sides are represented. It is seen that the matter has already been admitted by order dated 7/9/2024. No, 7/9/2023.
yes, Your Lordship.
On a query of the court. In response to the query of the court, it appears that although relevant records were called for, but all the materials which are connected with the writ petition are already on the record. So therefore, as no particular record has been identified for being called for, there's no necessity of calling for any of the records. Next, on the prayer made by Mr. Yapan, senior counsel assisted by Mr.
Kinyak lawyer.
Key lawyer, Your Lordship.
K. Lawyer, learned counsel for the year 4. Year 4,
R5.
respondent 5. Matter stands adjourned today. List. After seeing due vacation on a date to be fixed by the registry.
Any date, Lordship. Any date.
It will come because every matter now we are being adjourning after
Lordship.
there will be difficulty in handling it.
All right.
Release the matter for hearing. After the.
My lord, in item 3, my lord, on the last occasion, Mr. Mao, he committed that he will take instruction whether he will file his wakalat now. It seems prior to that also, the his counsels were not appearing on several occasions.
Nobody is appearing.
On the last occasion, Mr. Mao, he submitted that he will be taking instruction whether he will be filing wakalat nama in this matter.
This is a case for the previous counsel.
Since
There's
it seems there is
representation
no more
from the-
interest.
There's no representation from the petitioner. We've seen that the petitioner was not represented for some time. So however, on 8/2/2024 and 34/2024, a submission was made on behalf of the petitioner by Mr. S. Mohan, counsel as well as his colleague, Miss S. Somo, TSOMO, that they would take instructions and would be filing wakalatnama on behalf of the petitioner. Stop. He's seen that it is seen from the office note dated 29/4/2024 that wakalatnama on behalf of the petitioner has not been filed. On an earlier occasion also, Mr. Tayum, Tayum, had paid for some time to file wakalatnama, and he also had not filed the wakalatnama. Under the circumstances, as the petitioner remains unrepresented, matter stands dismissed for non-procedural.
Obliged, madam.
Any question I will be disposed of.
Made to the laws. My lord, 5 to 9 are connected matters. 5 to 8 are appeal against the conviction. And item number 9 has been filed by the complainant against 3 persons who have been, my lord, acquitted. Now, my lord, I have been informed only last night that the appellant in item number 5, that is criminal appeal number 2, they would like to engage a different lawyer.
Is it?
Yes, so maybe after 4 weeks, my lord. Only in item number 5.
You are appearing as legal aid counsel,
No, my lord. I was appearing as a private counsel,
as a private counsel.
but I really understand that his case might be a bit different, so you'd like to do it.
But other matters,
Other matters I continue to be there. Only 2 years,
can we segregate the matters and take it up?
my lord.
Can we segregate the matters and take it up? You are saying so.
No, my lord, that will be difficult. Same FIR, same conviction, same set of evidences, man. Same family, in fact, they are in fact brothers, man.
No, you see, the difficulty is that once you are on record,
Man.
you have to file.
Might not be just adjourned, I'm just apprising on what has happened yesterday. Might not be just adjourned in the meantime.
Okay, because your wakalatnama has to be
Yes,
decided,
yes.
otherwise you
Yes,
will
I
be,
understand.
liable.
Yes.
We just say
But
that
since,
out of
yes,
prayer we are adjourning
yes,
it.
but since they don't want me, so it's
No,
not.
that's okay, but formally you have to discharge.
I have
the
understood,
wakalatnama,
madam.
otherwise your liability remains.
No, I have understood, madam.
We-
My lord, may just adjourn it, my lord, in the
we
meantime.
adjourn it. Okay. All sides are represented. Prayer made by Mr. D. Pagani, Planet Council for the Appellant. The matter stands adjourned today. This after answering the vacation. On a date we pick by the district.
Obliged.
This just right hand SABP, all sides including SABP is present.
May I please, Your Lordship, I beg to mention item number 12, Your Lordship. Here, Your Lordship, the conducting counsel, Miss R. Basar, she is out of station, Your Lordship. Therefore, Your Lordship may kindly adjourn this matter for next week, Your Lordship.
Item 12.
Yes, Your Lordship.
Otherwise, this matter is ready for disposal, Your Lordship.
Huh?
This matter is for admission hearing. So can it be next week, Your Lordship?
Yes, next week, any date. Your Lordship.
Just on 7/4/2025, as paid for by land council for the respondent.
Yes, your lordship.
Okay. For private respondent.
No.
Official respondent.
Oh, it's a government, okay. On payment and government agreement. Okay,
Obliged, your lordship.
Can it be on tenth, your lordship? Tenth, on tenth of April,
no, not 10th, 7th.
seventh,
Obliged,
obliged.
obliged.
May I lordship? Lordship, I beg to mention item number 22 and 23. Lordship, here the service is not completed and the interim has been already granted. That may be kindly continue. And
You renew the prayer when the matter reaches, because if it is service report, then we'll have to ensure that steps are taken.
My
You
lordship,
renew the prayer when the matter reaches. If service report is not complete, we'll have to pass orders for fresh steps maybe. Renew the prayer when the matter is called. Okay,
let him-
when the matter is called, then make their prayer.
Yeah, please. Lordship, I beg to mention item number 16. Here, Lordship, conducting council is out of station. So kindly matter may be taken up after 2 weeks.
Okay. List after 2 weeks as paid for by land council for the petitioner. Okay.
Hello.
My lord, I mentioned item number 27. I on behalf of K. Taja, leading counsel, K. Taja is out of station. His personal problem. Matter may be listed after 2 weeks. I consult the defendant counsel.
Which was a representative of the prayer made by land council for the petitioner, list after 2 weeks.
Your Honor, may I beg to mention item number 9 and 10. Your Honor, this matter has become infructuous, so the petitioner is seeking for disposal of the matter.
Pardon, please repeat again.
The matter has become infructuous, so the petitioner is seeking for withdrawal of the matter and disposal of the matter.
Okay. Your name
M. Tama. I'm a
and
M. Tama. I'm appearing on behalf
name
of,
is not there.
Your Honor, I'm appearing on behalf of N. Cargo, Lending Cargo.
Okay. On instructions, Mr. N. Tamar, learned counsel, appearing on behalf of Mr. N. Kago, learned counsel for the petitioner, submits that the matter has become infructuous and therefore he has instructions to withdraw the writ petition. The respondents are represented, the prayer is allowed, the matter is dismissed on withdrawal. Okay, just make a note, if any interim order is there, it is to be vacated. If the interim order is not there, then don't write that. Okay, 9 with 10. What is this IA for?
Your Honor, I is on the main case
Huh?
for the payment of bill. The work is already completed. Bill is also already paid.
I think then order will be passed in item 10 and item 9 is in view of order this matter is dismissed from withdrawal. Huh? Okay.
Oh, please.
Please, Your Lordship, I would like to mention item number 19.
I think
I have taken
19.
19. I have taken consent from the government side. So this matter.
Where is come for orders?
It may be fixed after 2 weeks. There were some steps to be taken. I have not gone through the record. So
Okay, go through the record because we won't adjourn order matters without knowing. Check the records, make a prayer when the matter is called.
Yes.
Yeah, Lordship. I would like to mention item number 6 and 7 on behalf of Standing Council, Tabung Education. Lordship, we need some more time to file affidavit in opposition.
But you have taken a long time. I think from January 2024, it is pending.
Yes, Lordship.
Who is to give you instructions?
Pardon, Lordship.
Who is the authority who is required to give you instructions?
No hurries, Lordship.
Just give that record. Just renew the prayer when the matter is called.
Yes, Lordship.
It's okay. We will take it up after some time.
Item number 1.
My lord, I asked the officer to send me the hard copy, but they have sent me on WhatsApp, so it's getting
No, it's
printed.
okay. What does it say?
That completion report, they said that the firm was registered in the year 2021 is upgradations. Since 2019, it was there, firm. So earlier it was class 4. Then it was upgraded in 2021.
No, that's not the point. The point is that he submitted 3 tenders on
Yeah.
one day. So in the first tender, he says that the first tender, he said previous tenders, if any, was nil. And therefore he's saying that the criteria in which it was his bid was discarded was not correct because there's no pending work by the petitioner. And therefore in the first tender, he said nil. And in the other tenders, he gave the particulars of the tenders, and that was accepted, and the first one was rejected. That is the point. We will issue a notice. Also, you voting on counsel for the petitioner. Also heard Mr. G. Tarak, standing counsel for the RWD, representing respondent numbers 1 to 5.
1 to 5.
Next paragraph. Case of the petitioner is that on what is the date when you participated in the tender?
18/3 also.
18?
3/20.
18/3/2025, the petitioner had submitted his respective bids in respect of 3 numbers of tenders. So it is submitted that prior to that, he had no pending contract with the RWD. And he had also not submitted any other bid. And therefore, in which is the clause? Mr. Bori, which is that clause?
Lordship, this page 27 possible. Clause
In clause, therefore, in relevant
clause 1.3.2 B of
relevant clause 1.3.2 within bracket capital D
section
of section 3
and 4
relating to qualification information. The petitioner had mentioned nil. As on the same date, I 18/3/2025, the petitioner submitted 3 bids. The respondents had held the petitioner to be technically disqualified. Correct?
Yes, sir.
Technically disqualified. And accordingly, we said decision of the respondent authorities in the minutes of technical bid evaluation dated 19/3/2025, as well as the minutes of opening of financial bid evaluation dated 19/3/2025, in respect of the tender work for, what is the name of the work? For construction of 20-bedded hostel building, including kitchen and dining hall with warden room and 4-unit double-story type -Roman 2 quarter at government UPS TELAM within brackets POTTE bracket closed for an estimated cost of rupees 2,05,54,000 as held in this rate petition filed under Article 226 of the Constitution of India. Next one, issue notice returnable on 23/4/2025. So G. Tarak, standing counsel for the RWD, accepts notice on behalf of the respondent numbers 1 to 5. And accordingly, requisite extra copies of the rate petition be served on him in course of the day. Next, the petitioner shall take steps within 2 days for service of notice on the respondent numbers 6 and 7 by registered post with AD. First of the learned counsel for the petitioner is at liberty to collect the postal receipt number and submit postal track report prior to the next date of listing. Next problem. The learned counsel for the petitioner has prayed for interim relief for staying the impure minutes of technical bid evaluation dated 19/3/2025. First is technical bid and second is financial bid. Number 2, minutes of financial bid evaluation dated 19/3/2025. In respect of tender number, this number you can find at page 18. Tender number so and so, dated so and so, issued by executive engineer RWD Likavali division. The said prayer is opposed by the learned standing counsel for the RWD on the ground that the respondent, that the executive engineer RWD Likavali has already issued notice to proceed with the work on 24/3/2025. So accordingly, it is provided that the impure minutes, the 2 impure minutes dated 19/3/2025 as well as the notice to proceed with the work dated 24/3/2025 shall be subject to further orders that may be passed on the next date of listing. Next, the standing counsel for the RWD shall instruct the concerned authorities to produce the relevant records relating to the tender submitted by the petitioner. Three tenders submitted by the petitioner on 18/3/2025 on the next date of listing. Similarly, the petitioner shall also produce a copy of the all three tenders which has been submitted by stated to have been submitted by the petitioner on 18/3/2025 on the next date of listing. As per list on 23/4/2025. These three tenders you also produce, they will also produce.
Okay, let's see.
Which is examined on that next day.
Let's see.
These matters are subject to orders which are passed on next date.
Let's see.
Since notice to proceed with the work has already been issued, we are not staying it. But those are subject to further orders that may be passed on 24th.
24.
My lord, not only the issue, but then the area in question is also totally different from that letter. So,
Yes, sir.
That letter from the joint registrar I've seen, it is of 2023. It says about the pending cases.
You see, once anything is filed, it becomes pending. And when the principal, when it's under the orders of the Honorable Chief Justice. But the issue which Mr. Patel is saying is that they are, what do you call it? It is not a subject matter of the acquisition at all. It's a case of
my lord, yes.
where the acquisition proceedings have not been commenced.
And in any case, my lord, in paragraph 3, I have described because in that entire area.
No, we don't have, Mr. Patel, I have not applied my mind. Because once the additional advocate general
But
is
this
there.
is totally different area.
Without affidavit, we cannot say whether it is the same subject.
No, but you know the repetition, the prayer and the whether the issue is pending. That what you call the whatever pending acquisition matters are pending for this lower Subansiri hydroelectric project.
Yes.
That is required to be taken up by the principal seat. Now we adjourned on the last date. To give an opportunity to examine and then tell us.
My only understanding is that since it was of 2023, and at that point of time when it was.
No, you see, the issue relating to compensation is required to be taken up by the principal seat. So we are not tinkering with that.
Yes, madam.
We are not giving our own interpretation.
Yeah.
But Mr. Patel is saying that in this case, the land was not even acquired. And therefore, he is challenging that.
To acquire it as per law.
To acquire as per rule. So it is not pending. It is only that aspect you will have to examine.
Yes, madam. Now, whether in the initial notification, whether this area was covered or not, that will have to take instruction.
No, that was not covered.
Whether in respect of this land, an acquisition proceeding has taken up, that is for you to inquire.
Yes, my lord. For that, my lord, we'll have to file affidavit, my lord, whether it is.
Not required, the authorities will tell you. Because you see, they know the area.
Yes, ma'am.
They have the list of beneficiaries. They can just examine it and then tell us that whether the name of the petitioner in respect of land at place X is covered.
Yes, ma'am.
Yes, my lord.
Here, the respondent NHPC.
You see, the endeavor of the court is just that
NHPC will be
that
appropriate
the
authority.
order of the Honorable Chief Justice is not disregarded. Correct. But he has made out a point. In the last occasion, we issued a notice in respect of another petition. So Mr. Patil has a point, But
Yes.
we wanted to, you to examine so that we don't overreach.
The appropriate authority will be the NHPC, my lord, who will say whether this land also was.
No, but
So we are issuing
NHPC,
a
not that
notice,
acquiring.
subject to that clause, if it is pending, then it goes to principal seat, otherwise it remains here.
Yeah.
Okay. We already passed an order on the last occasion, which is that page? The earlier order we passed. In
No,
another- in another writ
there
petition-
is no impugn order, but they have not at all.
No, in the other writ petition, we passed an
Oh, my
order.
lord,
Where is that?
That is there in item number 25, item number 25.
Just show me that order.
Haritai.
Page number 127, my lord.
127.
Yes, my lord. I mean, item number 25.
No, the order which I passed earlier. Issue notice.
That, my lord, I have not annexed
Oh,
because
Uh,
in one.
Heard Mr. T. Patil, learned counsel for the petitioners, also heard stand of learned additional revision for the state. Representing respondent numbers
1, 2, and 3.
1, 2, and 3. Next person. The learned counsel for the petitioners has submitted that the that all the pending matters relating to issue of payment of compensation to the projected affected people for construction of Lower Subansiri hydropower project at Gerakamuk were ordered to be listed before the principal seat. Next, in this regard, it is submitted that in course of hearing of those matters, it came to light that the land acquisition proceedings were never initiated in respect of certain lands accordingly. The people whose land were taken over without any acquisition proceedings had approached this court by filing WBC 44 AP of 2025.
That is pertaining to the 1225. This is
That's okay.
816
That's okay.
separate area.
Next, it is submitted that in the present petition, the petitioners who are dwellers of Durpai, DURPAI, and other adjoining villages who are users of forest resources and dependent on the forest for their livelihood. Are affected because the community land
Some individual also clan, family, but then basically a maximum is community land.
community land and certain private lands were taken over for the said 2000 MW Subansiri Hydro Power Project without any acquisition proceedings in respect of how much land?
816 hectares.
816 acres.
Hectares.
Hectares, okay, hectares of land, which is more fully described in this writ petition.
Not, I have described that in paragraph 4. Details.
In paragraph
B
4 of
and
the
C.
writ petition.
Yes.
Okay. First, accordingly, comma, next, accordingly, comma, the land council petitioner submitted that on the aforesaid grounds, the present writ petition is different from those writ petitions which were called for by the principal seat. Next one. The matter was listed earlier by order dated, listed earlier and by order dated 1/4/2025. The matter was adjourned. So as to enable the granted State Council to obtain instructions. Next, the learned Additional Advocate General has submitted that as the instructions would only come from the project authorities. He is not in a position to address the court on that aspect. Next, accordingly, comma, that a notice returnable in 4 weeks be issued. As the learned Additional Advocate General has accepted notice of the requisite extra copies of the writ petition is served on him within 2 days.
4, 7 are steps.
We'll pass an order. The petitioner shall raise for service of this on the respondent numbers 4 to 7 by registered post with AD. In addition to usual steps, the petitioner shall serve notice on the respondent number 5 by just the mode by routing the process through the registry of the court, and upon service, an affidavit of service shall be filed prior to the next date of listing. Next, list after weeks.
In item number 25, which the file has been called, they have not yet filed affidavit.
Okay.
So maybe most probably these 2 cases can also be clubbed together.
This is service complete?
They're yet to file affidavit.
No, you have not taken steps.
No, Malan, I have taken the clerk, there was a clerical, mistakes from the clerk. So we have taken fresh steps.
I don't know, but the 29(3) reports is not.
Yes,
taken.
Malan.
Okay, in this item 29.
I may be given.
You say, but Mr. T. Patel, counsel for the petitioner, and Mr. N. Ratan, standing counsel for the additional division. Respondent numbers 1, 2, and 3. Next, in view of office note dated 29/3/2025, the petitioners shall take steps within 2 days for service of notice on the respondent numbers 4 and 5 by registered post with AD. In addition to usual next para, in addition to usual steps, the petitioner shall serve notice on respondent number 5 by the mode by routing the process through the registry of the court. And upon service, an affidavit of service will prior to the next date of listing. List after 4 weeks, along with WBC 139 AP of 2025.
Okay, fine.
Item number 3, this is the 5th time that we are approaching your lordship. The first case, the entire gamut has been taken care of by your lordship in WC 187, Annexure 1. In this earlier judgment, it was also held that we are maybe entitled for 13-month salary.
We issue notice
Because-
because we can't do anything else at this stage.
Otherwise, this can be disposed of next week, because this is entire, your lordship has taken note of all these sufferings. But since they have taken a policy decision not to implement the 13th pay, that means we are entitled for the other benefits.
We'll examine that again. Mr. T. Pandit, answer the petitioner.
We are on the backdrop that they have taken a policy decision not to provide the 13-month salary. Because whatever they are denying us is totally arbitrary and discriminatory. That's why. Otherwise, this entire matter has already been taken note of by your lordship.
Filing this repression on Article 26 of the Constitution of India, the petitioners who are MTS personnel under the Arunachal Pradesh Police have assumed the corrigendum dated 31/1/2022. As well as for direction upon the responsible authorities to provide the benefit of enhanced casual leave from 8 days to 15 days. And for direction upon the responsible authorities to frame service with the service conditions of the multitasking staff and other releases as paid for. Next one. The case of the petitioners is that although they are engaged as multitasking staff, but they are made to work as a regular police personnel, and they are also engaged in law and order duty. And accordingly, the learned counsel for the petitioners has submitted that the petitioners would be entitled to all the service conditions to which the regular police personnel are entitled to. Next, issue notice returnable in 4 weeks. Mr. Vairi Ram, the government advocate accepts notice on behalf of all the respondents.
Yes,
All the respondents. Accordingly, requisite extra copies of the petition will circulate in the course of the day. Next. In the affidavit in opposition to be filed by the respondents, the respondent authorities shall also take a stand that under which particular rules or notification the multitasking staff under the establishment of the Arunachal Pradesh Police are utilized for acting as uniform police personnel. In and engage in law and order and other police duties. Next paragraph. The learned government advocate shall transmit a downloaded copy of this order to the Director General of Police within bracket respond number 3. Next paragraph, this after 4 weeks. Obliged, Lordship.
My lordship,
We're issuing notice here. We're
Yes,
issuing a
ma'am.
notice here, but we'll give you a direction to bring on record the. I read somewhere, I forgot where. When the land is being acquired for any purpose, now you have a procedure to capture it by video or by photographs. That you'll produce.
I don't know whether that was done.
No, if
here.
it is not done, then the excess compensation required will be paid by your officers.
No, otherwise, there is an inquiry report, my lord will see
No, that's why we are asking. These inquiry reports and all, we don't find anything that anybody has visited those photographs.
at page 71, inquiry report.
Does it say that the photographs were looked into?
They have met physical.
Because now we are finding that in every land acquisition cases, the compensation claim comes on the 3 or 4 occasions. First is the land, then you say that there are zirats, then you say that there are constructions there, then you say that the land was more than what was acquired. 3 or 4 claims come up.
Yes, my lord. Here basically those structures, properties which were be created for claiming compensation in only with that motive. And
We
for that
understand.
they have
We understand, but then you'll have to tell us, you don't create a system in your state that in any construction which will come up must be with the approval of the authorities. So you are encouraging it. Please tell me, if you know that your land is being acquired, is there any law to prevent you from making a construction?
my lord, that's why in inquiry report they have found out.
This inquiry report business must stop.
Yes, ma'am.
You have a photograph, you show it. If you think that this is a new house, you give your reasoning, somebody must assess it.
Notice maybe.
And this house is built when? Who can say? By report only. No. You have to do concrete testing.
my lord, notice maybe issued.
Age of the house must be determined by someone. By visual inspection,
Here of course, my lord.
somebody will even say Taj Mahal was built yesterday.
Here, of course, my lord, what they have in the inquiry report, whether houses are built, which are
We
which
don't know, but
have
we
no
can't understand. There's no
specification.
clarity. By reading this report, at least I have
No
clarity.
flooring, nothing, only the structure outside.
What photographs show it?
My lord, we'll file it.
Right. And Mr. P. Tabakar and counsel for the petitioner. The case of the petitioners is that after a negotiated settlement in respect of the acquired land, comma, the assessment made, the claim made to the extent of rupees 20,91, 20,51 was accepted on 9/5/2023 by the Deputy Commissioner, Inkyong. In respect of the land which was acquired for construction of road from Inkyong to Moying, MOYING, within bracket 0.00 km TO2, 4.5 km. However, the 5-member inquiry committee set up by the Secretary, Land Management, Government of Arunachal Pradesh, evaluated the compensation to the extent of rupees 7, 70, 69, 271. Allegedly without participation of the petitioners or other projected affected families. And accordingly, by filing this repetition in Article 226 of the Constitution of India, the petitioner has prayed for setting aside of the inquiry report dated 15/1/2024 for a direction agreed land compensation, the acquisition compensation. Next paragraph. Issue notice returnable in 5 weeks. Mr. N. Rasan, the Additional Advocate General, accepts notice on behalf of all the respondents.
1 to 5. 6 is Union.
Respondent numbers 1 to 5. No government, no unit is not represented.
Central government councils are there. Others are there.
You should have told him the name is not shown. You should have told Mr. Katul. So next paragraph, it appears that the cost title does not reflect the name of DSGI, and therefore his he has perhaps missed the matter and is not present. Just to, nonetheless, as the landed DSGI would accept notice on behalf of respondent number 6. Extra copies of the petition to serve on the landed Additional Advocate General as well as the landed DSGI in 2 days. Next one. Along with the affidavit to be filed by the concerned respondents from the said respondents shall take a stand in the affidavit in opposition as to whether at the time of land acquisition, the authorities of the respondents have taken photographs of the acquired land. Moreover, in the event the respondents are disputing that the constructions on the land were created overnight only to claim compensation, the photographs of the concerned constructions shall also be compiled and filed along with the affidavit in opposition. Next, this after 4 weeks. Before that, you write the learned additional advocate generals and send a downloaded copy of this audit to the concerned respondents to bring the audit to their notice. Next, this after 4 weeks.
One more submission, Lordship. This execution part, this road, the project is going to be executed even if the structure is demolished. That can there be interim order?
It's already photographed. You take photographs and keep it.
Yes, that is there. So there is similarly situated
Infrastructure
case,
work we are
some
not stopping.
connected matter that may be clubbed together. WPC number 586 of 2024.
Okay, list along with
586 of 2024. Tagojism versus state of AP.
number. What is the number?
586
66 of
of
2024.
2024. Okay, that may be clubbed together.
Item number 5. May I please plead yours, Lordship. Well, in this matter, this matter also related to the.
Mr. Mo,
Yes.
if I am there, you may be in trouble. You see, in the earlier writ petition which came, you informed the court that you will take instructions and appear. And thereafter you did not appear. You should have filed a petition saying that you are not instructed. Because you see, once you make a submission before the court that you will be taking instructions, then it is your duty to inform the court. Otherwise, you are committing a dereliction of duty. Either you don't appear, and when you appear, and say take time to file wakalatnama. Please take it very seriously. I may be passing adverse orders. We don't want to trouble you by that, but we can still do it. So never do it because we had dismissed the petition on the ground for non-appearance. And if the respondents come and then take a stand against you, you will be in deep trouble. This is giving you a word of caution.
Well, in this matter,
Yes.
my lord, as per order dated 26/6/2024, your lordship was placed to direct for file affidavits. But then still they have not yet filed affidavits.
Your Lordship, I regret to inform Your Lordship that we have not received the pairwise comment till the Your Lordship.
Who is the authority to give you instructions?
Pardon, Your Lordship.
Who is the authority to give you instructions?
Deputy Commissioner.
We'll ask him to be in office. And we'll leave only after they leave, after he gives you instructions. He'll take leave and he'll come to you and stay in your office till you have instructions. But Mr. Esmolan, counsel for the petitioners. Petitioners. That's better. The Mr. Y. Ram, the government advocate, pays for some more time to file affidavit in opposition. In this case, the notice of motion was issued by order dated 29/11/2023. And despite several adjournments, the affidavit in opposition has not been filed. Next slide. On a query of the court as to who is the authority to provide instructions and pairwise comments, the government advocate has submitted that the instructions should come from the Deputy Commissioner from the Bangwadi district. Next paragraph. Having seen that, after notice of motion was issued, the matter was adjourned on 7 dates. We direct the Deputy Commissioner, Divang Valley District, to appear before the office of the Senior Government Advocate in Guwahati High Court, Itanagar Bench, UPI, on 21/4/2025 at 10:30 a.m. and shall stay back till the affidavit is prepared and signed and sworn by him. For the purpose of traveling to file this affidavit in opposition, the Deputy Commissioner shall take leave and this period of time spent for traveling and filing of the affidavit in opposition shall not be treated as a time spent on duty. Next paragraph. Let a copy of this order the government advocate shall transmit a copy of this order to the Deputy Commissioner, Divang Valley District, as well as to the Chief Secretary to the Government of Arunachal Pradesh, bring the order to the notice of those two authorities. Next paragraph. List on 28/4/2024. The affidavit in opposition shall be filed at least 2 days prior to the next date of listing.
Obliged.
No, Lordship. Lordship, counter affidavit not yet filed.
What is the matter? Termination order.
Lordship.
Yes.
Yes, Your Honor, I'm appearing on behalf of Stabatang Standing Council for Admission. We need to seek instruction from the department.
Instruction will not come, we'll restore him, then you take up steps to suspend and terminate him. We restore it back. How many days will be the person wait?
Kindly give us one more
No,
opportunity.
you go out, speak to the people and tell us, what is the date when you are filing your affidavit in opposition?
After Puja vacation,
Otherwise,
we'll file.
no, don't take personal responsibility. It will be very bad. Because we'll record your undertaking and then you will be in deep trouble. Let us go out, have instructions when they are filing this affidavit. We need a specific time. We'll take it up at 2 o'clock.
Obliged.
Yes.
Hello, this is pertaining to my revenue bill. The petitioner was awarded.
Just a minute. Non-payment of yes.
This is a scheme by union or government, my lord. We yet to receive, my lord, payment from the
Payment from?
the is
Respondent number two. saying
Mixture power,
Lordship.
my lord. Union of Government, my lord.
Lordship,
Yes,
I am
Mr. Roy.
Lordship, I am appearing for respondent number two, Lordship.
Yes.
They are saying that they have not received fund from us. Lordship, our stand is that they have not submitted the utilization certificate. That's why we have not released. And the project in concern is the scheme has been already over by 2022, Lordship. This is
No,
our
if
stand.
you, I don't get it, Mr. Roy. If you
Lordship.
don't give funds, how will you get a fund utilization certificate?
Lordship, we have given Lordship. We have given Lordship. We have released the fund, Lordship. They have not, Lordship. I have given one.
Where is your
there is a-
affidavit?
Lordship, that this is the latest letter, Lordship. My friend will hand over it,
No, no.
Lordship. Kindly
No,
see
where is your affidavit?
Lordship. My affidavit. Kindly see page 160. Running page is 160. This is Lordship 160. This is a request for giving them.
Yes. Against this letter, what is your reply?
No reply.
Page
Lordship.
160. What is your reply, Mr. Parme?
Pardon, my lord.
In response to page 160 of the affidavit by Mr. Roy, what is your stand?
116, my lord.
Lordship, I have just given one letter my friend has submitted. My lord, this letter, this is the recent letter. Lordship, kindly see, Lordship, what they have stated. They have given to us on 23/2025 after filing of the Lordship. Submission of final utilization along with the claim document for the project dated so and so. In continuation of this office letter 28/25 and 12/3/25, I am directed to inform you that the utilization certificate for the scheme so and so and its annexure GFR Form 1 submitted through email dated 9/3/2025 is hereby withdrawn. The documents such as utilization certificate annexure to so and so, earlier dated so and so may kindly be treated as corrected. Correct. Now, Lordship, it is also to inform you that rupees 1. After sanction, Lordship, we have recovered this amount from them as a loan interest, Lordship, which was recovered from the IPTS IT project so and so by your good office so and so. Interest has been placed in budget estimate of 2024-25, and upon receipt of the fund from the state government, fund will be utilized in full and utilization certificate will be submitted accordingly, Lordship. That means, Lordship, they have not yet submitted the utilization certificate till today, Lordship. And they are claiming.
May I clarify, my lord? My lord, here in this case, my lord will see on report, my lord. They have
your officers have sufficient property because we'll be awarding interest to be recovered from the officer.
Lordship,
you will pay Mr. Kato and then you will recover the amount from the officers' interest. I think your officers have sufficient property.
My lord, officer has done their part, my lord. I will indicate that from the record, my lord. What here happened in this case, my lord? My lord will see, my lord. This is a scheme, my lord, by the Union Government in the pattern of 85 and 15, my lord. 15 by state, 85 by central, my lord. Now in terms of that sanction order was issued, my lord. So
is it a part of work order to Mr. Kato that interdepartmental communication will prevent you from disbursing the amount?
No, my lord, that is
Supposing you start writing letters to the Union of India and Union of India starts replying you,
my lord.
Will it mean that the contractor will sit for 10 years for payment?
No, no, that is not matter.
It's not there. So who is the officer who is responsible for making payment? Will award interest to be recovered from him.
My lord, before that, my lord, I will clear. Here in this case, my lord, on the record, my lord, they have released 214 crore, my lord. To ask,
You see, Mr. Kato is not even bothered whether you got release of money or not. It is your marriage of convenience with the Union of India. What you do is within your family is your business.
yes, my lord, but we, my lord, enter into agreement with the petitioner on the instance of the sanction order issued by the Union government, my lord.
Yes.
That issue, my lord.
Then
So this is central scheme, my lord, Pandey central scheme, my lord. Now, on our part, my lord, that's why, my lord, kindly have a look at page one number 160, my lord, by the respondent number 2, my lord. 160, my lord, 160, my lord.
Yes.
160, my lord, we'll see, my lord. Down below in table form, my lord.
We have seen that, we have read it.
Table, my lord, table, my lord.
Correct.
Table, my lord, will UC submitted, my lord. UC submitted 1.96, my lord.
You
1.
have withdrawn. In this letter, you have withdrawn.
No, what this is letter by my lord, can you look at 160, my lord. This is letter by the respondent number 2, my lord, to Secretary Power, my lord, 160, my lord. 160, my lord.
You see, that is a letter of 11 December 2023.
My lord, my lord.
Now here it says balance UC to be submitted is 22.3 and 6.42.
My lord, not serial number 1. Serial number 2, my lord, is the relevant to this case, my lord. Serial number 1 is not, my lord.
Okay.
Serial number 2, my lord. Serial number pertaining to, we have submit 1.96, my lord. Serial number 2, my lord, is relevant to this case, my lord. Serial number 1 is not, my lord. Yes, my lord. Now 1.96 we have submitted, my lord. That they accepted this, that we have submitted a UC of 1.96, my lord. Now that
Look at the next page. Look at the next page. Page 161.
160, my lord, 160. 160, my lord.
After 160, there is 161.
My lord. In the case of non-availability return certificate, you see we last use with claim form submitted, but with the final process completion post, which they lead to report. In this case, my lord, before timeline, my lord, we submit the UC also, my lord. Thereafter, they have released this amount, my lord.
You want to say that the member secretary, Arunachal Pradesh Power Development Agency,
My lord.
his words are not to be accepted.
My
He's
lord,
a known false statement maker. Just show it to him.
Well, I've given him the copy, Lord. I've given him the copy.
Sorry, madam.
Now so either you certify that this man who has signed this document, he is known for making false statements. And that is why he rose to the capacity of member secretary. Can I tell a small joke?
Yes, my lord. This is my
without meaning anything bad to the members of the bar, because I was also a member. Can I tell you a small pipette?
Yes, my lord.
Somebody showed me a epitaph of a lawyer. In that epitaph of the lawyer, it was written, "Here lies a liar. He lied all his life and he is now still lying." I always remember this, because once you say page 161, then you read this. Here they have withdrawn that what you call the utilization certificate. After that, there is a recovery of 1.88 crore.
Yes, my lord. Yes, recover by the.
And your officer is admitting it.
Yes, recover, they are also admitting, my lord. Now they are insisting for the utilization
You
certificate of.
see, for that, you go to Supreme Court. Under Article 131A, dispute between the state and the center. Only the Supreme Court will have adjudicatory powers.
No, my lord, there is no dispute at all, my lord. Recovery of.
Then why don't you pay Mr. Kato?
Yes, my lord. Issue here is, my lord, only of 1.88 UC of the UC, my lord. Now they are also accepting the fact that, my lord, they have.
We are not adjudicating your dispute.
Yes.
Your dispute with Mr. Roy, we are not adjudicating that. Just give me the timeline when Mr. Kato will get payment.
My lord, will kindly appreciate here, my lord. Issue, my lord, recovery of 188, my lord.
You see, I have been lawyer.
My lord.
There were few people who said that we'll pay you tomorrow. And that tomorrow never came. I believe. That's why I believe that once it's a question of money, it is only money that can answer the query. Tomorrow never comes.
My lord, issue in our case is, my lord, one recovery 188, my lord, is not disputed, my lord. They are saying yes, we have recovered it, my lord. Respondent number 2, my lord, has recovered it, my lord. Now they are insisting for utilized certificate 188. What they have recovered, my lord. Now if they have recovered, my lord, how we can, my lord, issue utilization certificate recover by them, my lord? That the only issue, my lord. Now, in absence of that, you see, my lord, they are not releasing the other fund, my lord.
You see, having read this,
My lord.
Can you please come to this letter again?
Yes, my lord. This letter, I find it is correct, my lord. The contains some office letter dated 1/25, 28 to 25.
28 to 25.
My lord.
28 to 25 and 12/3/2025. I am directed to inform that the utilization certificate for the IPDS scheme and so through email on 19/3/2025 is withdrawn.
Yes, my lord. That is not relevant to this case, my lord.
Correct.
My lord.
Now, next line you say, it is to inform you that 1.88 crore, which was recovered from IPDS IT Phase 2 project by your good office.
My lord.
As so interest has been placed in the budget estimate of 24-25. And upon receipt of funds of the state government, funds will be utilized in full and utilization certificate will be submitted accordingly. Now you will place it in budget. The state government will make a budgetary provision. From that, they will give money. Whether they give money or not is not guaranteed. But where have you stated here that you are asking for recovered amount of utilization certificate from 1.88 crore? No government will ask for money recovered utilization certificate. Recovered money is recovered money. Utilization means that their funds had been utilized. If you have paid interest also, what is the difficulty in writing in the letter that some disturbance is coming? Mr. Roy, disturbance is from your end. Please check up. Now you see, if you have paid interest, what is wrong in giving a utilization certificate that you gave me 1 rupee and recovered 2 rupees as interest? Is it an ego problem of your officer? The central government has recovered money and why would I give utilization certificate? Has he a lot of ego?
Yes, my lord.
Yes.
Ported, my lord, kindly look at, I have find one epidemic in terms of order 23 to 25, my lord. This is, my lord, page start from page number 242, my lord. 242, my lord.
Yes.
Annexation number A, my lord, 249, my lord. This is its serial number 1, my lord. Serial number 1, my lord. This is the amount claim, my lord, past page per second, my lord, 214, my lord. They have recovered, my lord. This is their letter only, my lord. Letter by the respondent number 2, my lord. Letter only by the to ask, my lord. They said, my lord, in recover for RADF IE interest, my lord. They have recovered this amount, my lord. Out of 200, balance amount only 25 lakhs 36,000, my lord. They have released till that, my lord. My lord will see, my lord. Now, in terms of that, my lord, we have submit the UC before the timeline also, my lord. At next page, my lord, 250, my lord. This is 28 May 2022, my lord. It is in email, my lord. The UC is at 251, my lord. 251, my lord. UC is 251, my lord. This including this remaining 25.36 lakhs, my lord, or 25 lakhs 36,000, my lord. UC, my lord. With payment made to the contractor, my lord, at page number 252, my lord. This all documents is sent to them, or my lord will kindly note 27 March 2022, my lord. 27 March 2020, before closing of the this scheme, my lord. 27 March 2022, my lord. Now, all, my lord, this the contractor, my lord, executed the work prior to, my lord, completion date, my lord, and we also submitted the documents, my lord. Now, issue is, my lord, they are insisting for 1.80 submission of UC of the recovered amount, my lord. That's why, my lord, this is pending till that, my lord. In the sense of our submission, my lord, that's why, my lord, without left with no alternative, my lord, maybe, my lord, this time, my lord, the state authority, my lord, has tried for this budget.
Few moments back, I said, if you have any dispute with the central government, if they are asking for a UC certificate which you can't give,
my lord,
it's a dispute covered by Article 131, Clause A.
My lord.
A dispute between the center and the state, we can't take it up. But the fact remains that the contractor is not even bothered whether you have a dispute with the central government or not. It is your contract to pay it.
Yes, but to that extent, my lord, truly, I have no submission. Yes, he is big victimized, my lord, petitioner, my lord, in our dispute, my lord. But only I was supposed, like to express, humbly express, my lord, the issue, my lord.
Okay. Now, can for that reason, we ask the petitioner not to wait endlessly. Please tell us, what is the state government's instructions to you? That till you sort out the matter, the contract will not be paid. Have they said so in the affidavit?
No.
On our opinion, we are saying, my lord, not release of one, my lord.
But you see, in a writ petition, the issue between two of the respondents cannot be adjudicated. At least I don't know of that principle. That's why we are asking you. Interstate dispute between the defendants or respondents, can we deal with it in a writ petition filed by Mr. Kato?
Look, my humble submission, my lord, my lord will kindly, this latest letter by the respondent, my lord, they are saying, my lord,
Even lordship, one that I show.
my lord will kindly have a, my lord, one stain of the respondent number 2, my lord, at page number 162, my lord, 162, my lord.
Yes.
162, my lord. These are the dear stain now, my lord. 162, my lord. To letter to us, my lord. This is April 2, 2022, my lord. Second para I am reading, my lord. As you aware that for the IT phase 2, rupees 2 crore has been disbursed in Arunachal Pradesh utility.
How much is your dues?
But 6 crore 42 lakhs.
6 crore 42. My lord will kindly, but utility is yet to submit utility certificate. Corresponding state share along with associated documents are already disbursed. The remaining claim, my lord, will not, my lord. The remaining claim amount has already been forwarded to Ministry for consideration, my lord. As complete claim document has been received after March 2022, my lord. However, disbursement shall be made only upon submission of utilization and fulfillment for the constitutional. Now, they are saying, my lord, they have forwarded, my lord.
See, I will only understand what is the subject matter of the writ petition.
My lord.
Subject matter of the writ petition is recovery of 6 crore.
My lord.
From whatever letters you want, please show us that this 6 crore will be receivable by you.
Yes.
What you are now writing is 1 crore 28 lakh.
My lord.
1 crore 28 lakh is not the amount which is claimed by Mr. Kato.
My lord.
He's claiming 6 crore.
My lord.
Now, what will I do with understanding your 1 crore, 2 crore, 3 crore rupees here and there? What will happen? Even if I understand your financial transactions with the central government, please tell us, where does it take us?
No, your lordship.
Let us assume that you are trying to convince me and show me this financial transactions between you and the central government, response number 2. Where does it take us?
I am saying, my lord, if central release the fund, my lord, as he has completed the work, my lord, we will release, my lord.
That's why we are asking you, when you are showing us page 162, 162 does not relate to 6 crore rupees.
Lordship, one more thing, Lordship. If Lordship come to page number 232 of my affidavit, Lordship, this is after Electrical Power Division filed the affidavit. We have written a letter to the member secretary misrepresenting the fact, Lordship. 232, Lordship. This is on 21/2/2025 after receiving the affidavit in opposition from the Power Department, Lordship. This is the letter, Lordship.
Just a few moments back, we asked a question.
Lordship.
Member secretary, can we believe him? And that's okay. Whatever differences you have between you and respondent number 2, sort it out elsewhere. So far as the petitioner is concerned, releasing money within 3 months from today, failing which interest would be charged and made payable at the rate of 7%. And if your officers don't pay, the government will pay and recover it from you. Or those persons found responsible for the non-disbursement. Give you 3 months' time. If you have any differences, sort out in an appropriate forum with respondent number 2.
Only my party, work was completed in the year 2021. Work was completed in the year 2021. If the correspondence, if we peruse the correspondence made by the department and the central government, it will not complete it even within these 10 years.
We are not entering into those.
So therefore,
those we are giving
only
direction to-
interest part, that may be
My humble submission would be, my lord will kindly have a kind consideration on epidemic filed by me on in term of order dated 23/2/2025 by additional report, my lord.
Will not even refer to it. Will not even refer to it. We'll just refer it in 3 lines. We'll take a short break and come back. But your affidavits will be referred to in 3 lines.
Lordship permits, I wanted to take a small interest, why not? There are two items, my lord, today listed in the hearing list. I was not aware, in fact, these are not fixed matters. Today I had come for some other matters. I don't even have the files, my lord. Therefore, in morning also I did not mention, my lord. Then subsequently I came to know, my lord. These are listed.
Okay, which items?
Item 27 and 28, my lord.
Okay, just renew the prayer when the matters were.
I understand, my lord, this is going. Lordship would take more than that.
Heard. Mr. M. Kapoor, the counsel for the petitioner. Mr. Kato,
Ma'am.
you see, you are holding the post of DSGI. This respondent number two is a
No, my lord.
organization of the government
My
of
lord,
India.
I've checked out from the record, my lord. They are not, my lord, comes under the, my lord, the unit of India. My lord. They are in the corporation, my lord, having their own.
Lordship, I
Yes.
Lordship, I am appearing for the corporation by filing a wakalatnama, Lordship.
Yes, my lord. They are corporation.
No, but you see, in your affidavit, page 41,
Lordship.
the secretary, the undersecretary, the government of India
Lordship.
is treating you as its nodal agency.
Yeah, we are the nodal agency. Lordship. Corporation is the nodal agency, Lordship.
Well, main power are from the central government, but they are corporation, my lord.
We made a party because we are the nodal agency, Lordship. They have claimed nothing against us, Lordship.
Mr. Kato, the constable the petitioner. Also heard Mr. L. Permit when it's standing for the power department representing the respondent numbers 1, 3, and 4, and Mr. S.S. Roy, learned counsel for respondent number 2, who appears through video conference.
Lordship.
Next. It is not disputed by the respondents that the petitioner was awarded with the work of supply and page 16. Supply and installation of so and so IPDS. Name of the worker. at an estimated cost of rupees 838.00 lakh. For which contract agreement dated 9/3/2020 was entered between the petitioner and the superintending engineer within bracket electrical bracket closed Arunachal Pradesh Electrical Circle number 1, Department of Power. And it is also not in dispute that the superintending engineer within bracket electrical Arunachal Pradesh Electrical Circle 1 within bracket respondent number 4 had issued a work completion certificate dated 7/3/2022 in favor of the petitioner, by which wherein it was mentioned that the petitioner has successfully and satisfactorily completed the whole work. The case of the petitioner is that out of the total project cost of the contract cost, the petitioner has been paid only 20% payment amounting to rupees 1.96 crore, out of which the state share was rupees 1.25 crore. Semicolon. PMA charges. What is PMA? PMA. What is full form PMA?
I'm sorry, Maratha. Full form.
PMA charges was rupees 45.00 lakh, and amount against IPDS phase dash Roman 2 project was rupees 26 lakh, aggregating a sum of rupees 1.96 crore. And accordingly, the petitioner claims that the balance amount of rupees 6.42 crore has remained unpaid, despite issuance of letter of request, advocate's notice dated 7/2/2023, and representation dated 30/5/2023. And accordingly, this petition has been filed under Article 26 of the Constitution of India, seeking payment of the unpaid balance contractual bill of rupees 6,42,00,000. Next para. Although voluminous affidavit in opposition has been filed by the state respondent numbers 1, 3, and 4 and separately by the respondent number 2 and a further affidavit by respondent numbers 1, 3, and 4 against the affidavit in opposition filed by respondent number 2, comma, the court does not find any reason to burden this order with the stand taken in those affidavits, because of the fact that voluminous communication between the state respondents and the respondent number 2 revolves around nature of disbursements made by the Power Finance Corporation Limited, within bracket respondent number 2, and allegations and counter allegations relating to requests by the respondent number 2 for utilization certificates. According to the learned counsel for the power department, standing counsel for the power department, comma, the respondent number 2 is also claiming utilization certificate for amount recovered by them on account of interest. Therefore, comma, in the said affidavit, comma, it is not the stand of any of the respondents that the petitioner had not completed therefore, comma, any intra-party communication between the power department of the state and the Power Finance Corporation Limited, with like a respondent 2, is something which the said respondents would have to settle between themselves. Next paragraph. The basic issue raised in this writ petition is that although the petitioner was issued with a work completion certificate by the respondent number 4 on 7/3/2022, our balance amount as claimed by this writ petition was not paid to the petitioner. Next one. Although an effort was made by the court to examine the contents of the documents appended to those affidavits, but none of the documents lead to a conclusion that there is any dispute with regard to the completion of work by the petitioner. The various amounts referred to in various documents do not add to rupees 838.00 lakh, which is the contract amount. Or to rupees 6, 42,000. This is to be paid, which is due and payable to the petitioner. Next slide. Accordingly, comment is reiterated that if there is any dispute between the state respondents in the power department of the state of Arunachal Pradesh and the Power Finance Corporation, this state respondents within bracket respondent numbers 1, 3, and 4 on one part, and the Power Finance Corporation Limited within bracket respondent number 2 on the other part. It is for the two authorities to settle the interstate dispute in a manner as they may be so advised. Full stop. In none of the affidavits, it is the stand that the petitioner, that any correspondence from the petitioner was lacking, which prevented the state power department to issue a utilization certificate, or that any deficiencies on part of the petitioner prevented the respondent number 2 from accepting those utilization certificates. The court does not find that the petitioner is at fault for which the payment to the petitioner has been delayed. Next one, resulting to comma. The extent of work completed and the extent of payment due for the petitioner having not being a matter in dispute, comma. The interstate dispute between the power department of the state and the within bracket respondent numbers 1, 3, and 4, and the Power Finance Corporation Limited within bracket respondent number 2 did not come into the way of the court to direct the respondent numbers 1, 2, and 4, i.e. the state of Arunachal Pradesh, represented by the Commissioner within bracket Power, bracket was Chief Executive Officer, Arunachal Pradesh Power Department Agency, the Chief Engineer within bracket Power, Western Electrical Zone, State Nodal Officer, IPDS, Department of Power within bracket respondent number 3, and the Superintendent Engineer within bracket Electrical, bracket close, APEC-1 within bracket respondent number 4, to release the outstanding payment of the petitioner within an outer period of 3 clear months from the date of receipt of a certified copy of this. The date when a certified copy of this order is served on the respondent number 4, i.e. the Superintendent Engineer within bracket Electrical, APEC-1, who is the contracting authority with the petitioner. His contract was signed by respondent number 4.
Yes. Respondent number 4.
Three clear months, isn't it? 3 clear months. It will be May, June, i.e. 31/7/2025. Next, in the event the outstanding dues of the petitioner is not paid within 31/7/2025, the dues of the petitioner shall carry interest at the rate of 7% per annum, which will be disbursed by the state and recovered. We are with liberty to recover the amount from the from its officers who are found guilty of delaying the release of the amount due to the petitioner. Amount is so advised and in the manner after following all the requisite formalities and procedures. Next part of this, reiteration stands allowed. That's why there should be no orders to post.
Obliged, Your Lordship.
Development.
Obliged.
Lordship, this is just as per number 3 and 7, their affidavit is very vital. That is the deputy commissioner and a state officer. All the foreign people will find their affidavit.
You see, the issue raised, we don't need a affidavit in opposition. The government made a plan to plan for this
Proposed reserve forest.
proposed reserve
Typical
forest.
reserve forest.
You say that they have no right to withdraw it.
No, Lordship, they are not withdrawing it. We have submitted several representation before the concerned authorities. The only thing is that the deputy commissioner in the meeting of 1984, he himself said in a written format that this is not feasible because the area over there, it is inhabited by the humans.
What is your prayer?
Lordship, there are 3 prayers, 2 are
To quash the notification.
notification, Lordship, at 19, page number 90.
Page number
90.
90.
So not 90 lots. It's notification that page number 42. 42. 43 is the type copy. This is the preliminary notification under section 5. This has never been completed till today, nor is signed. Yes, number 53 will give a clear that respond number 3 has specifically communicated to the chief conservator of forest in the year 1986. Who is also a forest settlement officer.
Some forest regulation. Assam Forest Regulation, local acts. Yes, this affidavit has to be rejected for the respondents 1, 2, 4, 5, and 6. Yes, we'll have to reject your affidavit.
This forest department is sufficient, madam.
This affidavit says nothing. We are saying that we'll have to reject your affidavit. You'll have to file a fresh one.
It is saying that.
You see, the draft was made without looking at the act. You never consulted the act when this draft was made. Where is the final notification issued under section 17?
This is of course not, it was never issued.
Where is the affidavit that other formalities were completed?
It is said that there is no
problem
provision
is-
for draft notification.
See, that's why the problem is that you drafted it without looking at this act. Whoever settled the draft did it without looking at the act. Therefore, we
we'll
don't
fight
even know
for-
what is the nature of prayer the petitioner is making and what should be a response.
They will file for this respondent 3 months.
We don't know, this affidavit says nothing. This is by the
Forest department.
forest department.
Okay.
It says nothing.
They are only saying there is no provision, that's all.
Hmm?
Without any mention of this act, they are only saying there
No,
is
but
no.
how could the government advocate draft it and file it in the court? Speaks bad. We are rejecting your affidavit. You file a fresh one. This affidavit says nothing. Mr. K. Saxena and counsel for the petitioners is present. The petitioners, comma, number. I become and so and one and additional with general. And Mr. M. Kato then you are appearing as
Madam respondent number 88. Performer respondent.
You done a DSGA for respondent 8 are present. Next para.
We need it.
In the case of the petitioner, is that preliminary notification for (40 square kilometer) CP reserve forest was issued on 8/5/1980. And the claim within this writ petition, comma, amongst others, is for quashing of the said notification. Next, although the respondent numbers 1, 2, 4, 5, and 6 have filed a joint affidavit in opposition. But on a cursory perusal of the same, does not disclose about the compliance of section 5 to (15) and 17 of the said act of the Assam Forest Regulation, comma, 1891. as adopted by the what is it, Act, Arunachal Pradesh Act?
That is Arunachal construction of reference to state government regulation.
Huh? Where have you written that?
It is in the notification itself.
In the notification itself. Read with section 3 of the Arunachal Pradesh within bracket, construction of references to state government
Regulation.
regulation, 1965 as adopted and modified by the northeastern areas within bracket re-organization bracket closed again bracket Arunachal Pradesh bracket closed adoption of laws order, 1972. In other words, the said affidavit does not reflect as to whether any proclamation by the forest settlement officer was issued in as per the requirement of section 6, inquiry by the forest settlement officer as required under section 8, treatment of claims relating to practice of June cultivation as required under section 10. Orders, if any, on claims to right of way, on water course, pasture, etc., is required in section 11 and 12. And the right to provision, right to pasture, rights of pasture or to forest produce is required under section 13. Of the Assam Forest Regulation. Moreover, the final notification declaring of the forest reserve under section 17 of the Assam Forest Regulation is also not referred to. So accordingly, the said affidavit is not found worthy of reliance by the court, and accordingly the said affidavit does not help the court in the adjudication of the matter. Accordingly, the same is rejected. That's why we accordingly, the court grants 4 weeks time to the respondent numbers 1, 2, 4, 5, and 6 to file a fresh affidavit in opposition. And it is also provided that while the affidavit in opposition is, while instructions are issued to the running government advocate, and when the affidavits sworn, the concerned authority is swearing the affidavit shall apprise himself of the requester with the provisions of the Assam Forest Regulation, 1981, 1891. Specifically specifically the provisions of section 4 TO2 17 of the said regulation. That's why the learned additional advocate general shall send a downloaded copy of this order to the said respondents to bring this order to the notice of the said authorities. Next paragraph. Liberty is also granted to the respondent to file an affidavit in opposition from which advised. Next, we list out of votes. File a fresh affidavit doesn't take us anywhere.
Lordship, interim order is there.
Okay, interim order passed stands after. What is the interim order?
The letter of the Forest Department of 2024 has been stayed for further process.
The interim order passed stands extended to the next date of the state.
Obliged.
Lordship, here we are yet to file our response, Lordship. We need some more time.
2024 matter.
Lordship, this was filed in the December. We have communicated in January only, Lordship. This is since this was filed in the eve of winter break. After court was reopened, then only we could communicate. Otherwise, also there are two deputy commissioners here, Lordship, because earlier it used to be under the West Siang district, and then now it has bifurcated, and Lower Siang district has been created, Lordship. So therefore, because documents, Lordship, they are seeking from each other. So we need some time, Lordship, here. It's not a matter, the subject matter that he has not been paid. He's saying that he's not been paid fully. He has got already more than 70 lakhs, Lordship.
Okay. Which is the representative on the.
So we need instruction.
Is initiated on it. Additional senior government advocate. The magistrates adjourned to enable the state respondents to file their affidavits. Next paragraph, the learned additional senior government advocate has submitted that earlier the land comprised in undivided.
Lordship.
Which is the undivided district earlier?
West Siang district.
West Siang district, which has been bifurcated.
And now it's under
West Siang district as well as Lower Siang district.
Yes,
yes.
And therefore, the authorities and the process of exchanging documents between the two districts just to compile the response. In the explanation tendered, the magistrates adjourned today. 4 weeks additional time is granted to the state respondents to file their affidavit in opposition. Next one, list after 4 weeks.
Lordship, can I get 6 weeks time?
No, not 6. 6 weeks.
Yes, Lordship. so that it didn't come up and I had to take time again.
Okay, 6 weeks. Yes, you were saying something?
That's actually this, I'm this for 2 weeks only.
No, because if they have to exchange documents, there some require some time.
And that's if this legally place, earlier it comes under the West Siang. Thereafter, then Lower Siang was created. So on that ground, this 2 deputy commissioner has been raised.
No, we understand. That's why.
Yes,
we
that's what I
accepted
have
her
to make.
explanation.
Yes.
Obliged.
Because during bifurcation of districts, the documents are very hard to
Technically,
find.
it's okay.
Have to give them some time. Yes, what's your prayer?
My lord. Yesterday, my lord, the list came out in the evening. Before that, I was already here. I did not have the files, my
Which
lord.
items?
Item 28 and 29, my lord.
28, 29. Okay.
Can this be fixed, my lord, sometime in the first week of May? 7th May, my lord. I'll be here. Or otherwise, my lord, for 4 weeks.
Okay, 7th. Okay.
My lord.
John of the prayer.
Item 28 and 29.
So we contact council for the petition. List of 7/5/2025. You are also there?
Yes.
Okay,
Mr.
what
Kato
was
is
the
on the
procedure?
RS.
Even I will file counter affidavit within the petition.
Yes.
Finally, grant us 1 week of time for filing counter affidavit.
How much time?
1 week.
1 week.
Yes, sir.
Uh, Who says a representative? Upon instructions, Mr.
H. Tai.
H.
Tai on behalf of
Tai,
Tabat
appearing on behalf of Mr.
Tabat standing counsel for.
P. Thakur, the standing counsel for the Education Department.
Yes, sir.
Praise for and is granted 1 week's time to file affidavit in opposition in the matter. In view of the ensuing leave vacations, list on 23/4/2025.
Item number 14.
My lord, I'm entering appearance on behalf of the respondent number 6 in item number 14, my lord. My lord, in fact, this is the second round of litigation. Earlier, we had already exchanged pleadings. So lordship grants me 1 week's time, my lord, I can file the affidavit. my lord.
But the difficulty is that if we give longer adjournments, the petition would itself become infructuous.
That is his fault, my lord. For the simple reason, my lord, he filed a misconceived petition on the earlier occasion. After the affidavits were filed, pointing that out, it was withdrawn, my lord.
Well, but in this case, if your lordship says, we have took the dusty service on 20th January. So definitely, well, there was.
If my learned friend is, was it next week, my lord, by next week, I'm ready.
Okay. So you take it up on 11th?
Yes.
11th is, my lord. Yes, yes.
Yes.
My lord, not 11th, my lord. Not 11th, I will order, sir. 10th or 9th.
10th.
Okay. If you're taking it on 10th, then I will thank you.
Well, though it looks voluminous, Malat, I don't think Malat will take much time. Malat.
That's okay. Mr. Tako, Mr. Tako, you have seen this new look. Now I'm an old man.
In the morning itself, your lordship looks totally changed. Not changed.
Now I'm an old man. So I can't I can work fast.
My lord, we will not be troubling your lordship so much, my lord.
There's nothing to trouble, but the whole matter is infructuous.
No, we'll see. That's why, my lord, anyway, my lord, we
Mr.
want
D.
to.
Thakur and counsel for the petitioner is present. And Mr. Counsel for the petitioner and Mr. G. Tarak Lanet, standing counsel for the RWD are present. Mr. You have filed your Wakalatnama?
My lord, I filed, my lord, and by
Mr. D. Pani,
Tuesday, my lord, I will file the affidavit.
Huh? Okay, Mr. D. Pani, Learned Counsel, appearing for respondent number 6. Praise for is granted. Time till 9/4/2024 to file affidavit in opposition, 25 to file an affidavit in opposition to the matter. Next para, just on 10/4/2025.
इसको तो अपना मानो प्रेजेंसी नहीं हम फोटो भी कल ला देंगे petition को भी देंगे
And here we have filed affidavit regarding industry service under respondent number, my lord. 5 and 6, but they have not appeared. Well, government has filed its affidavit. My lord, in this matter,
It's just. Okay. So Peter Fuller, the counsel with the petitioner, has referred to the affidavit of the service filed on 28/1/2025. Project that the notice was served on respondent numbers 5 and 6, which was duly received after fixing the rubber stamp of the respondent numbers 5 and 6. Accordingly, the notice to the respondent numbers 5 and 6 is deemed to be duly served. Yes, Mr. Tarak, you have filed your affidavit.
Yes.
Mr. G. Tarak, standing counsel for the RWD, has submitted that an affidavit in opposition has been filed by respondent numbers 1 to 4. Yes, Mr. Thakur, what do you want to say?
my lord, if your lordship would take up this matter, my lord.
Okay, when do you want, Mr. Thakur?
If your lordship, today, if I can just make my lord, submission regarding, my lord, this matter is
Not today, we'll take it up Monday.
Monday, lordship. Yes.
Okay. List on 11. Sorry, 7.
7. Published.
Yeah, my lord. This is a simple case, my lord. I only seek direction from this honorable court. If my land is affected, it may be acquired under 2013 Act. No, my lord,
Lordship, last occasion, this court asked me to bring instruction, Lordship.
But these instructions.
Instruction I have received, Lordship, is premature, Lordship. It's yet, this area is yet to be notified, Lordship.
then my lord, this matter may be disposed of with a direction, my lord. If they want to acquire,
No, it's not required. If- if
That
they-
is
if
not
they take
required,
penalty-
Lordship. We have said so here in this one. Whenever the acquisition start, Lordship, they will know, Lordship. It will be notified, Lordship.
So be Pichar and counsel for the petitioner. I heard Mr. B. Pichar and counsel for the petitioner. Also, the G8, we have it. We have this. Learned, additional scenario, that's why this G8, additional scenario and advocate for the respondents. Next one. By filing this writ petition under Article 226 of the Constitution of India, the petitioner there is a land and building near 173.450 kilometer of Dirang village. Has expressed his apprehension that his land and property may be affected by the highway widening. Accordingly, the learned counsel for the petitioner has submitted that in the event the land of the petitioner falls within the area earmarked for expansion of the highway, the land acquisition process should be initiated by the responding authorities. Stop. It is also projected that in the meanwhile, the responding authorities have valued the property of the petitioner for a sum of rupees 49,52,466. The petitioners paid for question of the said relation report on the ground that the procedure prescribed under the right to fair compensation and transparency in land acquisition, rehabilitation and resettlement act, 2013 should be followed. Next one. Where is that document of land valuation?
land valuation, my lord, yes, my lord. It is, my lord, in page number 44, my lord. Serial number 1 pertains to the writ petition. No solution, nothing, my lord.
Next, the learned additional senior government advocate has produced a copy of instructions dated instructions by letter dated 27/2/2025 issued by the additional deputy commissioner, Dirang, West Kamen district. And it is submitted that the present petition is premature because the acquisition notification has not yet been issued. Next, the contents of the said . letter number DRG oblique LR dash 10. This is the one. So and so, dated so and so is extracted below. Next. In the contents of the said letter, it is apparent that the notification of land acquisition has not yet been issued. And the authorities have not even decided as to which act will be applied for acquisition of the land. Under such circumstances, as on date, this present petition is to be premature. So according to this, the petition stands closed. It diverted the petitioner to approach again if he is still aggrieved by any action that has been initiated in respect of his land.
My lord, what is the case, my lord, my lord? This, my lord, this was, my lord, page 42, my lord. The board was constituted, my lord. Now, on 15 March
No,
2020.
you see, valuation has been done, but nothing more.
I am only, my lord, by virtue of this board, my lord, the valuation was done, my lord. Page 43. Page 43, my lord.
No, in this instruction, that's why we have quoted this letter.
My lord.
As per this letter, they have not even decided which act will be followed.
Yes,
My
Lord.
lord.
Only thereafter you will have a cause of action.
Well, yes. So, my lord, what, because of the, my lord, what was the necessity to prepare this valuation, my lord? Because, my lord, this valuation was also forwarded to the deputy commissioner.
No, let them do it. How you are affected by that?
My lord, I am on the apprehension, but by this valuation, they will be paying me the
Let us-
compensation. my lord.
No, let us, we'll say it like this. I have a pencil in my hand.
My lord.
Supposing you, for your own, you assess the value of this pencil
My lord.
at 100 rupees.
My lord.
Correct. Please tell us what prejudice is caused to me.
My lord,
I am holding this pencil.
my lord.
You have made a valuation of rupees 100 of this pencil. This pencil is otherwise available in the market at 10 rupees.
My lord.
Correct. Now, what prejudice do I suffer with the valuation you have made of my pencil?
My lord, because they have already exercised, my lord. They have
Yes,
already
okay,
exercised, my lord. They have constituted bonds, my lord.
The government is not taking away illegally.
My lord.
They will not just go and throw you out and occupy the premises.
My lord.
Now they'll have to issue some notification.
My lord, that is why, my lord, if, my lord, they are,
No, if and buts, we can't pass writ on that.
my lord, may I please come to page, this one, my lord. Page 51, my lord.
Yes.
Page 51, my lord, this, my lord, border organization, my lord, Grave, my lord, has written letter to the ADC, my lord. Yes, my land is going to be affected, my lord. My land and property, my lord. Now, my lord, before that, they have already exercised, my lord.
Going to be affected
My lord.
and having been affected are two different things.
My lord. Since they have done the exercise, my lord.
We've given you liberty to come back again.
My lord.
If any adverse orders are passed to your interests.
Then, my lord, I have submitted my representation. This may be disposed of, my lord.
No. Disposal of represented, this is nothing, I'm not passing such orders. Mr. Pichai, I am very clear.
My lord.
Only when you are aggrieved, you can file a representation. Let us say that tomorrow, 20 lakh people in this state start giving a representation that if you want my land, please do this, do that, and dispose of my representation. What will happen to the government?
My lord, at least, my lord, the
No.
exercise they have conducted, my lord. It is not me, my lord. The board they have constituted, my lord, they have, my lord, made the valuation, my lord. Without.
It's okay, they have done it.
Yes, my lord.
How will you agree by that?
My lord.
They are spending their own money, they are conducting a survey, they are valuing your property.
Right.
How do you suffer any prejudice? Please tell us.
Say, suppose, my lord, by virtue of this, my lord, tomorrow they will pass an award, my lord.
Come again.
No way.
Come again.
No way.
My lord, I am only praying for, my lord, if they want to acquire, my lord.
If is something which has not happened. No writ on ifs and buts.
Well, because they are going to acquire, my lord.
Can't help it. Ifs and buts doesn't give rise to a cause of action.
My lord.
Now let us, if supposing today we pass this order,
My lord.
tomorrow you come again, saying that a survey is made, there'll be a bridge which will be built just before this High Court.
My lord.
They have done the survey, soil testing was done.
Right.
And now therefore, I am a contractor. If they want to build the bridge, they have to give me a notice of tender. Is it possible for us to do so?
My lord,
Ifs and buts. They have done a survey. Tomorrow they will do a tender. I am interested in that tender. Or ifs and buts. Every government does many things.
But government
They even send a satellite, go up there, and then every inch of the state is being mapped.
But in my case, my lord, government has already exercised, my lord.
No.
No.
We are writing, we are quoting this letter.
My lord. Only a, my lord, observation, my lord, in that
No.
case, my lord. If, my lord, the acquisition is initiated, my lord, it may be.
Again, if.
My lord. Because, my lord.
Writ under Article 226, you see, it's very elementary.
Right.
Writ can be issued only one is really aggrieved by something.
Right. Well, I'm agree.
Some interest of the person must have been affected, which gives rise to, which disturbs his fundamental rights, and he has a right to oppose the court. Now, what fundamental right has been affected by you? I'm asking a elementary question.
My lord. But I am only aggrieved by the valuation, my lord. Without invoking any law, my lord, they have made valuation.
Without any fundamental right being affected, is a writ petition maintainable? Second question.
My lord. Because my lane is going to be affected, my lord, as per the, my lord.
Going to be, it's not affected.
And before that, they have made the valuation, my lord.
Tell us, we are asking two simple questions. Elementary.
I am aggrieved by the valuation, my lord.
Agree by the valuation.
Valuation, my lord, because it has not been initiated, my lord, without invoking any law, my lord. It has been valued, my lord.
How you are affected? Tell us.
By this, my lord, only by this.
How your fundamental rights have been affected by valuation? Mr. Picha, I have a long vote to finish.
Well,
I'm asking a very simple question.
Yes, my lord.
What fundamental right is affected?
My lord, my valuation, my lord, Article 21, my lord. Article 21, my lord.
Article 21.
Yes, my lord.
You want an order from the court?
No, my lord. No,
It will look very bad when I pass this order.
No.
Because I will say that, let me write it. Once you are pressing.
No, my lord.
No, why not? You see, the members of the bar are there. They will think that the court is helpless with that question.
No.
I have to answer it.
No.
Let me answer that question.
No, all right, no.
Then it's a basic LLB curriculum question. Fundamental rights when a writ petition is maintainable. You read survey, volume 1. There's made a good description of that. Don't make me say what I describe.
Item 18 also same, my lord.
This is similar method.
Similar.
Because Mr. Picha,
My lord.
I have a habit of entering the court while smiling. I want to go out with a big smile.
My lord.
Correct.
My lord.
But if I change my character, it will be very difficult for the bar. I'm really telling you.
My lord.
It will be very difficult for the bar.
My lord.
Because when I come prepared, at times you will find that I am more prepared than many of the lawyers. And when I start dictatorship in court, it will not be good. You are all rising stars. This bar I like. That's why I come so regularly. At the drop of the hat, I give my consent to come here because I like this bar.
Not.
Correct?
Yes, sir.
But if I make statements in the order against these fundamental issues, it looks very bad on the, it reflects very bad. We don't want to do it. That's why I give you Second is also same.
Same, only the valuation would be different. Valuation amount would be 11,90,700.
Second is rupees
He is also the agreed.
11, 90, 700.
Yes, sir.
And the location is
Same.
same.
Chain is same.
Same. Okay.
Obliged.
Yes, please, your lordship, I may be allowed to take fresh steps. I have seen that the steps are still awaited. Upon a respondent meeting.
Mr. A. Bhattacharya, learned counsel for the petitioner. Has referred to the office note dated 11/2/2025 and 4/2/2025, and submits that the service report on respondent number 8 and 9 is still awaited. Next para. The petitioner shall take fresh steps for service of notice on the respondent numbers 8 and 9 by registered post with AD. Shall check steps within 2 days for service of notice on the respondent number 8 and 9 by registered post with AD. Next para. The learned counsel for the petitioner is at liberty to collect the postal receipt number from the registry and submit postal track report prior to the next date of listing. Next para. List on. Give a date after 5 weeks. Second May. No, second May is 4 weeks. No, we're 5 weeks. Okay. Make it on 9th May, because he'll take 2 days in taking steps, 2-3 days for the registry to do it. Okay.
May I, my lord?
Yes.
Here, my lord, here I was supposed to file affidavit in reply, my lord, to the affidavit opposition by state respondent, my lord. I could not, my lord. I pray some more time, my lord. 2 weeks, my lord.
Mr. I. Kamil, and counsel for this petitioner, pays for his granted 2 weeks time to file affidavit in replying the matter. Ms. Peace, Sangeeta, learned government advocate is present. Okay, list after
2 weeks.
2 weeks.
High level. In this case, my lord, this my lord, matter become infructuous, my lord. Yes, in terms of retender was also issue, my lord, in this case, my lord. And okay, on again, this after retender is on 5/6/2024, my lord.
Non-appeals for the petitioner on call. Of the office note dated 2/4/2025 also reflects that neither EDICA nor answer notice is received in respect of respondent number 6 and 7. Next para, be that as it may, Mr. L. Parveen, learned standing counsel for the power department, has produced a copy of notice inviting tender dated 5/6/2024, and it is submitted that in respect of the contract work, which is for which the current writ petition was filed, has already been put to retender. Next para, the copy of the notice inviting e-tender, comma, as produced by the learned standing counsel for the power department. It's made a part of the court. Next, this writ petition stands closed, having been rendered infructuous. You are appearing?
Yes, madam.
You are there. The retender has been issued.
But my friend, I maybe around some time to take instruction. If this is the case, my lord, then we'll, my lord,
Now you'll have to file otherwise also.
yes. We'll challenge the, my lord, the NIT president.
Success in matter will close. However, the closure of this writ petition will not preclude the petitioner to take approach the court again if they are aggrieved by the retender.
Well, lordship is closing this
Closing
present.
this with liberty to you. If
May-
you want to challenge the retender, you do it.
Let my friend, that may be, my lord.
Give a copy to him. Otherwise, he'll not be able to
Yes,
take.
madam.
give instructions. Mr. Kato, make copy and give it to us. We'll give it on record. He has only one copy.
Yes, madam.
Take this. You can give instructions.
Let my friend, writ petition may be kept alive, my lord.
Yes, okay. But give us a copy.
Yes,
We'll do it.
I will do.
Then last year, set aside that, that part. You say that accordingly, Mr. M. Karthik, counsel for the petition, prays for some time to obtain instructions
Well.
and address the court. Next further. List the matter.
On 7, my lord. I'll come with it, my lord.
7 for 22.
Well,
Okay.
deep.
Oh, yes.
You said recording is presence. I said nobody appears. Record presence of Mr. Kato. Yes.
Yeah. I'm from the petitioner side, not side.
Pardon me.
I'm from the petitioner side.
Yes, yes.
Service is not completed here. From the respondent number
Yes.
4.
Who is respondent who?
Respondent number 4 is a private party. Private party.
This deputy director.
Pardon, Lord, sir?
He's the deputy director. Why you have treated him by name? Why is this deputy director
Sri
treated by name?
Sri Dohan Taksing, Deputy Director of School
Why
Education.
have you treated him by name?
Dohan Taksing.
Why? Question is, why have you implemented him by name?
You know, the transfer order was issued by the DSC on Yingkiong Upper Siang District. Therefore, he has implemented as a respondent party in this matter.
So this person was transferred in his.
This person was transferred from Yingkiong Upper Siang District, Your Honor. From NSCB AV Mayung to GUPS ALC line 210.
Well, the petitioner is a teacher.
Yes, Your Honor, he's a teacher.
We are listing it tomorrow. You please address us why this respondent four was made party by name. We don't
Lord
find
Sir,
any,
uh,
we don't find any pleading of malafide against this deputy director. He can't be impeached by name. You are not asking for any relief against him. Why would you impeach the deputy director by name? We are listing it tomorrow. Please address us on that.
Lord Sir, my senior, he's out of station. So,
Tomorrow he'll be here? No.
no, he's out of Arunachal. So,
When will it be next available?
after 2 weeks, Lord Sir.
After 2 weeks.
Yes.
Okay.
Lord Sir, and interim is there. So,
Okay, both sides are represented.
interim may be continued.
The office note indicates that notice was not served on respondent before. So accordingly, the petitioner shall take steps within 4/2025 for service of notice on respondent before. Next paragraph. So by registered post AD, the learned counsel for the petitioner is at liberty to collect the postal receipt number and submit postal track report to the registry prior to the next date of listing. Next paragraph. On the next date, the learned counsel for the petitioner shall inform the court as to where is the pleadings with regard to allegations of malafide against respondent number 4, and shall address the court why the deputy director of school education has been impleted by name. Next one. The issuance of notice on respondent number 4 shall not be a bar for the court to examine that aspect of the matter. Next one. The notice is made written on 7/5/2025. So list accordingly.
Lord Sir, interim may continue.
Interim order passed at this stands extended to the next date of listing. Next for how the respondents are at liberty to apply for modification of the order from my advised. Okay.
Mature. Lord Sir, this is the same. Yes. 22.
Same.
Yes. Same order may be passed.
Same order here also.
Much pleasure.
May I please, my lord?
Yes.
My lord, service report regarding respondent number 4 is still awaited now.
It was issued on January. Take first steps. And consult the petitioner and your name?
M. Doziman.
M. Dozi, and consult the petitioner as well as Mr. Y. Diran that are government admit are present. Next paragraph. Office note dated 2/4/2025 indicates that service report is not received in respect of respondent number 4. Expect accordingly. The petitioner shall take first steps within 2 days for service of notice on the respondent number 4 by registered post with AD. Next paragraph, the learned counsel for the petitioner is at liberty to collect the postal receipt number and shall submit the postal track report prior to the next date of listing. Next paragraph. Notice is made returnable on 7/5/2025. So please take a look.
Okay.
Item number 26.
Lordship, here the direction was to take steps. Accordingly, we have taken steps. However, the office note is stating that we have not taken steps. It seems there has been some miscommunication. So Lordship may kindly allow us to take first steps.
Mr.
T Gatso.
T.
Gatso.
Gatto, the Learned Counsel for the petition submits, has produced a copy of proof of steps taken on 33/2025. Sorry, 23/2025 for service of notice on respondent numbers 3 and 4. Photocopy thereof, which is produced by the Learned Counsel for the petitioner, is kept in record. So the office shall track the set steps and issue notice, which is made returnable on 7/5/2025. Next paragraph, P. Sangeeta and Government Advocate is present. Next paragraph. The learned will collect the postal receipt number and submit postal track prior to the next date also. List on 7/5/2025.
There's interim, your lordship, kindly.
Interim on the past list and send it to the next date of listing. You've taken steps, it will go on. You don't take first steps. But you collect the postal receipt number and submit postal track report. Otherwise, this postal steps is very slow. If the small things are done, you will be expediting the matters. Okay.